Good afternoon, everyone, and welcome to this Canberra Business Chamber webinar on changes in casual employment and independent contractors. I'm Greg Harford, the Chief Executive of the Canberra Business Chamber, and I'm delighted to be joined today by Olivia Perry, and I'll introduce her in a moment. But just to confirm, the government has passed, the Commonwealth Government has passed a new definition of employment under the Fair Work Act. That will come into effect from the 26th of August and will impact your business. So in this webinar, we're going to be helping you understand the multifactorial test for determining employee status and how independent contractors may be affected, as well as gain some insights from the Fair Work Commission's new powers on unfair contract terms. This stuff sounds very complicated, but it is really important because it is going to affect almost every business in the country, and we're going to unpack the details of that this afternoon. If you do have any questions, please use the Q&A function at the bottom of your screen and we'll get to those at the end. But in the meantime, I'd love to introduce to you Olivia Perry. So Olivia is a senior workplace relations consultant who supports our members. She's got a degree in law and arts, but has a passion for employment law and has been working within the HR and industrial relations industry for over 6 years. She assists a multitude of clients in different industries daily, and her role on topics as diverse as performance management, redundancies, employment contracts, and indeed the status of casual employees and independent contractors. So Olivia, I'll hand over to you. As I say, we'll look back at the end for any questions. So please just do use the Q&A function at the bottom of your screen. Olivia.
Thank you very much. Sorry, So just to start off, we wanted to give a bit of a breakdown of all the changes that have been, since 2023, and then some updated ones that will be coming through over the course of 2024 and 2025. As a little bit of background, so basically over the last year, as you can see, employers saw really substantial reform to the Australian employment law landscape, one of the biggest ones being the two different Fair Work legislation amendments for the closing loophole bills. That was introduced in 2023. However, the decision was made to introduce those sporadically, as you can see, over 2024 to 2025 as well. So the bill was divided basically within two, with those changes to be passed in two different trenches. So that first option being the closing loophole bill, which was received in Royal Assent on the 14th of December 2022. And that second one being the beginning of 2023 on the 26th of February 2024. The changes implemented by the bill take effect obviously in that staged approach. So there's this key list of commencement dates here in this image. As both the bills really brought significant changes to a lot of different legislation areas, as mentioned, it's really crucial for employers to understand these changes and ensure that workplaces are compliant. There will be obviously different areas where there could potentially be financial detriment for not issuing these changes or following these key changes. So it's very important that you're across all of these. The key changes for the closing loophole bill number 2 are the right to disconnect, changes to underpayments and right of entry for suspected underpayments, the new definitions for employee and employer, the new definition for a casual worker, regulations for gig economy workers, regulations for road transport workers, so that's quite a specific one there, dispute resolution mechanisms for unfair contracts. There's also changes which will be coming up for new enterprise agreement bargaining, which in regard to that multi-enterprise agreements and franchisees. So again, quite niche and only applicable if you do have an enterprise agreement, of course. But as mentioned today, we'll be mainly diving into the changes that will be in accordance with the 26th of August, so coming up very soon in relation to those new definitions. So I'm going to go into the casual definitions options first. Basically, there was a contentious issue of casual employment rights in the specific case of WorkPac and Risado. So basically, as a breakdown for that case, it involves Mr. Risado, who worked as a casual employee for a mining company, WorkPac. That was over a period of 3 years. So despite being labelled as a casual, Risado worked quite regular and really predictable shifts. So the central question before the court in that scenario was whether the employee is classified as a casual, but working really regular shifts, which would result in potentially the employee being a permanent employee. And if they are classed as a permanent employee, should they then be entitled to paid leave benefits under those national employment standards? So as you can imagine, annual leave and personal leave as well. Basically, the court's decision, which was actually delivered in 2022, ruled in favour of Rosado, which basically determined that despite being classified as a casual, Rosado's consistent work patterns indicated more of a permanent employment relationship. And as a result, the court found that he was then entitled to annual leave payments under those national employment standards. Following that case, it really prompted these significant legislation changes in Australia, and obviously was input within those closing loopholes and provided more clarity, which are set to come into effect in August. So those key changes and new definitions, basically the definition of a casual employment is what is the main focus of that being changed. So it basically introduces a new statutory definition of casual employment. A casual employee is now defined as someone who accepts a job offer from an employer knowing that there is no firm advance commitment to ongoing work with an agreed pattern of work. So this definition basically aims to distinguish casual employment from permanent to part-time employment. Basically, with the closing loopholes introduction, these amendments to the definition are within now Section 15A of the Fair Work Act. And as a casual employee who is basically one, again, that meets those requirements. And it is something that kind of goes on the basis of step by step. So does the employee have no firm advancement of continuing or indefinite work? And is the employee entitled to casual loading or a rate as specified for casuals? So when determining the existence of firm advance commitment, it requires the consideration of what we say the real substance or practical reality and true nature of the relationship between the employee and employer. And much like other areas of the law, it can be really broad and it can be sort of quite grey and not black and white. And it really does come down to a reasonable person test at all times. So always look at things from the perspective of, I'm a third party, I'm looking at this from a reasonable third party perspective. Would I look at this role and potentially see that there's that firm advance commitment for continued shifts? And obviously, if you're looking at that from that perspective and you see it as yes, then you may be at risk of potential for that permanent employment rather than casual employment. A few key considerations to examine when looking at that would be whether the employer can choose to offer the employee work, whether the employee can choose to accept or reject this offer, which I will go into a little bit more detail about, and whether the employee has a regular pattern of work. Additionally, the new amendments also change the casual conversion process. So this is now called the employee choice process. So basically now after 6 months of work, or in the case of a small business, which is 15 employees or less for a small business, in that case, it is 12 months instead of 6 months. Employees can choose to notify the employee in writing if they believe that they no longer meet the definition of a casual employee and then wish to convert to permanency. In response to that, employers have 21 days to respond to this request by either converting the employee to permanent and giving a contract as such, or noting that they are not actually eligible for that conversion, and they can have that opportunity after another 12-month period. Finally, employees will need to provide, and I just want to really just quickly touch on this one because it should be something that we're already completing at the moment already, but employers are really urged to provide all casual employees with a copy of the casual employment information statement as soon as practicable upon commencing work. If you haven't done that as such at the moment, I'd probably just suggest sending, if you have casuals, a casual information statement. There is also a Fair Work information statement that should be sent to all staff. So I'd probably just suggest sending a all staff email with that, complying to note that you are sending that as an informational statement. So to dive a little bit more into it, the new definition as you can see here, is these two different dot points that I've already kind of discussed and touched on. I did just want to touch on a few different rights as well. So there's obviously that criteria or that requirement to discuss casual conversion with staff, and staff have the eligibility to request. And obviously, as mentioned, you can only refuse conversion in those very limited circumstances where essentially they don't meet the applicability for a permanent employment. In regards to an element called casual loading and offset, so this legislation addresses the issue of what we call double dipping, I guess, but by ensuring that casual employees who receive a casual loading, so that hourly rate higher of pay, are then not entitled to things such as paid leave. So, this hasn't been a huge change, but something that they did with insert in these definitions, just to make sure that there's clarity and they prevent claims for both casual loading and entitlements such as annual leave. There's also claims for permanent entitlements. So as mentioned, you do need to look potentially retrospectively, especially as whether they've been applied as a casual loading or not. And also just basically seeks to strive a balance between protecting the employee's rights and as well as ensuring fairness for employers within that retrospective check for casual employees. So whether there's a firm advance commitment to continuing and indefinite work, so you can see that first dot point there for the definition. A few things that you could, or tips that you could look at for assessments are whether there's a real substance and practical reality and true nature of the employment relationship is that there's that commitment and that firm advancement. If the employment, as an example, is for a short period of a project, and that's why you're hiring a casual potentially, there's that sort of understanding that there's that end or there's not a continuation. So that's where you can feel quite safe in that. In comparison, if somebody's working every Wednesday and Thursday, for example, with a client, let's say, and there's that consistency that the clients will continuously be there every Wednesday and Thursday, and there's that, assumption that there'll be that definite work period, that's where you may need to look at the potential for that permanency. Some other factors that can be considered is whether the employer can offer or not offer the work. So whether it's actually happening or not, is there an actual workload there to actually give to a permanent employee? The employee can obviously, as I mentioned, accept or reject that as well. They may just wish to be casual, and that's perfectly fine. I would just make sure in terms of record keeping, as a tip, that you keep a very solid record of the fact that they did decide to remain casual as an employee. So you've got that date and acceptance, and even a signature is best option to confirm that they did reject that. It's also reasonably likely that as another assessment, that there will be future work available to the employer's business. So based on the nature of the business. So again, an employee may be with one client every Wednesday and Thursday, but there's an assumption that if that client cancelled, they would just slot in a different client in that Wednesday and Thursday space. So within that, there could be an argument for permanency in the basis that the nature of the business is that you could continue those shifts. Another applicable consideration maybe is if there's a bunch of similar roles, if those additional roles are full-time or part-time and they're performing the same kind of work in the employer's business as the work the employee usually performs, another indicator of that as well. And as mentioned, a really big indicator is whether they're continuing that regular pattern of work for a long period of time. So just continuing on with that firm advancement. So again, sort of mentioned the considerations here, but that whether there's an ability to actually elect to offer that work is obviously quite important, and that substance also. There isn't a continuation that all of these need to be met here. These are all just kind of tips for the employers essentially, but if most of these are fulfilled, or again, if a reasonable person would look at it and say, yep, this is a permanent employment, generally there would be that argument for that as well. Obviously, again, every situation is different, so you can't have a blanket answer for everything. But again, for lack of a better way of saying it, I always do say, if it walks like a duck and quacks like a duck, it probably is a duck. So I always try and use that sort of method when looking at these, and especially even further down, looking at employee versus contractor when we get into it. A reasonable person can, generally speaking, look at that process, look at those clients, look at the way that their employment is structured and their days and hours, and work out whether it's sort of more on the side of that employee and permanent role, or employee and casual role as well. Sorry. So just a little bit of a breakdown of how does a casual employee become permanent. Sorry, thank you. So with that pathway, as I mentioned, this kind of replaces the current rules, but they are still quite similar for changing that employment. But basically, as mentioned, the employees have that ability now to notify their employer of their change. And the steps are basically, if they've been employed for at least 6 months, so always as your first point, has the employee been here for 6 months? Again, 12 months for your small business. And secondly, do they believe that they no longer meet the requirements of the new casual definition? If both of those are fulfilled, I would then, as a business owner or an employer, review potentially the advancement. So review whether you feel as though that there's that continuation of work at a firm basis, and then review their roster. Apologies. So looking at their roster is a really good way to see whether there's that continuation as well. Once you've made that investigation, again, we'd do that quite promptly because you do have 21 days to respond to the employee. You then have the option again to either consult with the employee, and I would suggest having a consultation, especially if you are rejecting the permanency. And would discuss certain details of what will change if the employer either accepts the notification or obviously rejects it as well. If they accept the notification, obviously the employee will no longer be a casual employee, and that will affect potentially their salary as well. Obviously, discretionally, you may wish to keep the salary as is, but most of the time it will affect, especially if you're following along with award rates as well. So if that is altering, obviously there'll be a discussion that they will be receiving or starting to receive annual leave and personal leave. My suggestion when changing over and having that consultation would be to set some barriers or explain a policy in regards to your business as to how to apply for annual leave, as well as how to apply for personal leave. In some situations, it may be that the employee's never done that before. So always a suggestion to starting, as you're starting fresh, to make sure that they're aware that, potentially if you're off sick for more than 2 days, you need to provide a medical certificate, and that process of how to apply for annual leave, all those sort of notifications, which are handy to know when you are transitioning. A few other elements there may be your employment contract. So there may be a requirement for you to enact a new employment contract. The reason for that being, again, that there's that applicability for leave in that change or potentially a new salary. You can, in some circumstances, just send a variation letter. However, the suggestion would probably be more of a new contract instead. With that change from casual to permanency as well, I did want to note that with that transition, it doesn't mean that their probation period restarts all of a sudden, or that they may not have eligibility for their prior service in regards to long service leave. So just keeping that in mind as well. Majority of the time, the only change is your potential salary, obviously permanent hours and days, which should be stipulated within their contract and consulted about in regards to that change, as well as obviously annual leave and personal leave, like I've said a couple of times. So just touching on the employee grounds for declining. So firstly, if the employer refuses to change, you must include the reasons for that refusal. So there can be a multitude of reasons, obviously, some of those being that potentially the employee still meets the definition of a casual, obviously. You do need to note the fact that there were fair and reasonable operational grounds for not accepting the notification. So some of these may include substantial changes would be required to the way in which an employer's business works in order to organise that change. Potentially those substantial changes to the employee's conditions wouldn't be reasonable to ensure that there's that non-compliance with potentially an award. Or accepting the change may mean that the employer isn't complying with the requirement or selection process required by law as well. So a few options there. Obviously, the main one would probably be that the employee doesn't meet the definition of a casual. But generally speaking, you do need to give pretty succinct reasons as to that refusal. Again, my suggestion would be to make sure that in the process of investigating that and making that decision, that you keep your records up to date and really succinct into the reasonings as to why and why that reasonableness test was assessed as to the fact that there wasn't operational grounds that you could move to permanency. With those changes, again, would make sure that there's a document explaining that to the casual, there is a consultation, and would probably suggest a signature from both the employer and the employee on a document to make sure that you're prepared for that record should anyone come to question why that employee is still a casual. Further to that, this is just a touch base quickly, but if a dispute arises and it can't be resolved at the workplace level between the employee and the employer, the dispute can be heard by the Commission. The Commission will generally first try to resolve the dispute in a really informal way, so it may include things such as mediation or a conciliation. However, if it can't be just resolved within that conciliation, that does then get moved to the Commission and they are able to arbitrate the dispute. So that next step is obviously a more formal process and can result in a really legally binding decision as well. So let's get through these. So what does this mean for your business? So some of the implications for employees and employers are basically that they may need to go through a really thorough review as an employer to adjust your employment practices to comply with the new definitions as well as those conversion rights. And you need to make sure that you're accurately classifying and communicating the nature of employment really early within the discussions of an employment as well. So what I'd suggest in terms of your onboarding process is ensuring that they're robust enough to look into those and make sure that those who are engaged as a casual worker are aware that they are engaged in that basis. I guess in that onboarding process as well, making sure that all new workers that come in, you are looking at their roster, looking at their details and making sure that they are a true casual prior to any kind of onboarding or advertising for that role as well. What I would suggest as well, as you can see here, is a casual employment audit. So looking at all your casuals, especially those who are over 6 months, to making sure that there's a system in place to make sure you're managing where somebody is within their first 6 months or 12 months if you're a small business, and really looking at their engagement, the way their role is functioning, their days and hours, all those sort of things that we've discussed. Make sure that your casuals are actually a casual employee base. As mentioned, this isn't in here, but records for all of those are extremely important and crucial. Should something come up in a few months after employment, it's always a good touch base to go back and keep those records, of course. And just looping back in a bit of a summary, that casual employment information statement, sharing that around and having that downloaded is a really easy way to make sure that you're complying with these changes as well. So I'm now going to jump into employee and employer. Apologies, sorry. So as kind of mentioned with as a result of the amendments for the Fair Work Act, it's now changing the definitions in regards to employee and employer. And this involves an assessment of the real substance, practical reality and true nature of the relationship between the two parties. So as we've kind of spoken about, this amendment reversed to the multifactorial approach and basically overturns the 2022 findings in the High Court, which was between CFMMEU and personnel contracting. So the intention of that change to the common law test is basically that there's a fairer process when applied in determining a worker's status. We have had this quite substantially over the last few years in regards to contractors and making sure that contractors in relation to superannuation and the multi-indicia test are being met. So our suggestion to all of our clients as we've been going through has been to sort of enact this or sort of begin this process much prior to the August date, which is upcoming, just because contractors can be, a bit of a process to negotiate and alter if need be. I did just want to quickly touch base on the fact that if individuals earn above the high income threshold as a contractor, you can actually opt out of being defined as an employee. And I'll discuss this a little bit more, but this was a major change, as this can be exercised by either the worker or the employee by way of written notice. And these opt-out notices can be revoked at any time as well. So with these changes, something to really be aware of is the risk of sham contracting. So what is sham contracting? Basically, sham contracting is misrepresenting an employment arrangement as an independent contractor arrangement when they're meant to be an employee. So employers who engage in sham contracting can be penalised. The previous offence to sham contracting claims and also be known as the recklessness test, sort of more change to that sham contracting now. But again, it kind of loops back to that reasonable person test or that reasonableness test. It's in everything in the law. Within that as well, to defend a sham contracting claim, an employer must now prove that at the time of the representation was made, they reasonably believed that the worker was to be engaged as a contractor rather than employee. So there is that burden of proof on the employer to prove that there was that belief there. So it's important to make sure that we're really assessing the changes that have come in and really assessing our contractors, if we have any, to make sure that that test is being met. So the test we've all been speaking of, the multi-indicia test. So basically, this multi-factor test refers to a set of criteria or factors, which I'm going to go into detail for, but are used to determine whether an individual is considered an employee or a contractor. So this test is crucial in assessing the nature of the working relationship and has obviously become really increasingly important with these changes. So a little bit of a background on the test. Historically, the distinction, between employees and contractors was based on various factors that indicates the degree of control, independence, and the integration of the individual into the business. The distinction is critical, but as it determines the entitlements, rights, and obligations under law as well. So some of those things, as mentioned, will be control, integration, risk and responsibility, tools and equipment, method of payment, contractual obligations as well. Again, I'll go into a little bit more of a detailed table next. But employers are obviously really encouraged within this process to review their employment contracts as well as contractual obligations to ensure compliance with the updated definitions and criteria outlined. Providing that clarity within this closing loophole has been really crucial because it has been, I would say, slightly confusing previously in regards to these changes. And there were actually changes over the last period in relation to superannuation and contractors. So having these new definitions will really help to make sure that we're paying our staff correctly and in the best manner possible for these employees too. So as mentioned, a little table here for you, just because I felt like it might be a little bit easier. What we do suggest for our clients is kind of utilising a table like this. As a suggestion, I do know the ATO have a very similar table which outline in a little bit more detail the definitions or that test. And so they are quite heavily everywhere at the moment. Obviously, they kind of outline the key difference between contractors and employees. With that main definition, something that I always try and look at is the status. If they are a contractor, they're generally engaged as an independent contractor, often through a contract of services. If they're considered self-employed and run their own business. So as an example, if my business is myself, Olivia Perry, and I can contract myself out to multiple areas and I'm more self-employed, run my own business and can work for multiple clients simultaneously and sequentially, there's that example that I have more control and independence than an employee. Within that control as well, as a contractor, you have the control, or that you can exercise a high degree of control over where, when, and how your work is performed. So including the ability also to subcontract or delegate tasks out as well. Generally speaking, and this isn't always the best test, but generally speaking, a contractor will provide their own tools and equipment. Again, not always the case with this one, but another good example as well. And obviously they've got that flexibility in setting their work hours, their location. Generally they're subject to contractual arrangements, of course, but again, another sort of indication of a contractor compared to an employee. A really big one is your financial arrangements. If at the end of a period of work, the employer invoices a client for work completed based on agreed rates or project milestones, another good factor that they are a contractor instead. A contractor will generally also manage their own tax obligations, potentially including GST if applicable as well. And there's also generally an assumed responsibility for business expenses. So some of those may be, as mentioned, a subcontractor, insurance, liability for the work performed, those kind of aspects as well. Obviously, in comparison, an employee would come under the employer's insurance and liability entitlements. I've mentioned this a little bit before, but of course, if they are seen as a contractor, they're generally not entitled to things such as paid leave, sick leave, annual leave, all those kind of specifics. Previously, again, I did want to just touch on the fact that typically, or at some points, contractors are not eligible for superannuation, but I'd always suggest touching base with an accountant. Those have been altered slightly. So some contractors are actually eligible for superannuation. So always a good point to, if you have contractors, to confirm and check in with your accountants in regards to that. Just to touch base on your legal protections as well, a contractor will generally not have unfair dismissal protections under the Fair Work Act. There are some circumstances where if you are engaged in certain conditions, they may have unfair dismissal protections. That's generally if they're in a condition where they're resembling an employment relationship. So you're in that aspect of potentially sham contracting because you've engaged someone who is meant to be an employee as a contractor, and that may be why they have those unfair dismissal protections. On the flip side, of course, additionally, an employee will pretty much have the complete opposite to whatever the contractor is have. So they'll have an employment contract with some sort of permanent part-time or casual employment. And they'll have a lot less control and direction in regards to how they run their day by day. So they'll work under more direction and control of the employer. They'll follow companies' policies and procedures. They'll generally be paid a pay slip after, a fortnight or monthly, whichever way you function. So their financial agreements and arrangements are different. And obviously they'll have a lot more protections in regards to your national employment standards for leave and unfair dismissal, should that be applicable as well. So just looking through, again, employers versus contractors. So with back pay for unpaid entitlements, they will not arise for workers who were contractors under the old version of the Act, and will change in status to employers as a result of the new amendment. However, some employers or workers' employment liabilities, just noting, did start accruing from 27 February 2024. I did say I'd talk a little bit more about that opt-out notice. Basically, with those choice for high-income contractors, I believe it's sitting around the 167,000 at this stage. That will alter on 1 July, so just keeping that in mind. But basically, those workers who are more than the high income threshold will be able to opt out of applying for the new definition through a notification process. With that notification process, if a worker's earnings are in that threshold, a principal or employer will be able to give the worker a written notice explaining that the worker can give them an opt-out chance. This can be done when the principal or employer thinks that the worker may be an employment relationship because of the new definition. and then wish to opt out for that notice so that they won't apply to the definition for their relationship. Within that process, a worker can revoke an opt-out notice by any time within written notice, and timeframes and additional requirements will obviously apply within as well. So those 21 days generally. So just looking now at unfair contracts. So again, this is another one that starts on the 26th of August, but contractors will be able to apply to the Fair Work Commission if they think that their service or services contracts have an unfair contract term within them. So another tip that I would suggest is potentially having your contractor or even your contracts for your casuals, whatever you have, really reviewed and looked at for any unfair contract terms. A little bit broad to say what that may or may not mean, of course, at this stage, but having potentially a lawyer or a service review those contracts is a good way to make sure that you're complying. A services contract is obviously a contract that relates to the performance of work by a contractor. And within these changes, the Fair Work Commission can take a few things into account. So the relative bargaining power of the parties, any significant imbalance in obligations. So if it's seen that the contractor is potentially giving, too much in comparison to the flip side, obviously that can sort of show that imbalance. With a lot of these, again, it is kind of that reasonable person test or, what the Fair Work Commission will take into account. So it's hard to say a specific amount, which would be seen as an imbalance. So, again, it can be quite difficult, but always looking at from that third party or, reasonable perspective. Sometimes I like to look at things of, if this was my contract, would I feel as though this was unfair or harsh or unjust in any way? And if potentially when looking at it, I did feel that way, it may be something to look at and adjust or even, confer with other legal representative or providers to make sure that is a fair term, sorry. Within that process, the Commission can also make an order to set aside, amend or vary all or part of the contract if it is found that there's one or more unfair contract terms. The new laws will only apply where there's a constitutional connection. So, for example, if the contractor performs work under a services contract with a constitutional corporation, that will obviously alter the way these changes and unfair contract terms are managed. Contractors working above the high income threshold basically can't apply for that unfair contract remedy within the Commission. So again, something to note for that high income threshold there. Something that I think is quite important to touch base on is that second last dot point as well. It isn't generally in practice the way things run, but if the remuneration of the contractor is less than what you would normally pay an employee in the same role, something to really look at because that can be an unfair contract term as well. So making sure that you're really assessing all of your contracts, your salaries, your rosters for these casuals and contractors arrangements, hopefully prior to the 26th of August is really key in these. So what does this mean for your business? So some of the key takeaways and tips, I would say. So speak with any independent contractors now to make them aware of any possible threat of new status arising with the new definition of employment. It's quite key with that as well because it may alter some of their salary, it may alter some of their entitlements. And again, it may potentially mean that you need to alter the way in which you work or the relationship in which you work with that contractor. So obviously, 26th of August is quite soon. So touching base as soon as possible is really key. I've mentioned this a few times now, but record keeping is critical in every aspect of HR and employment relations. So ensuring all your documents are recorded between both parties genuinely, and all contracts are within that space of a relationship and set through for your contractors and your casuals in a really succinct way is really important. When you're looking at these, making sure that you're considering those opt-out. So you could almost potentially just pull data for all your staff and have a look at salaries. and checking if they are above that high income threshold could be a really good way to navigate any potential next steps as well. And again, another touch base would be ensuring that all contractual documentation, contains only fair terms. So again, and a really quick way to look at that would potentially be taking, your employer hat off, and reviewing some of your terms as if you were the contractor or the employee. If you feel as though they would be unfair, then it may be something to navigate and look at. Employers or contractors as well should really be mindful in these processes that, among other things, the conduct of the parties in practice after a contract is entered into will be considered in determining the true nature of the relationship. So that means that businesses may engage an individual with the understanding that they're hired as an independent contractor, but then later could be found as an employee. And then attached to that, it may mean a number of employee-related entitlements flow on, and potentially the prospect of underpayment claims from there. So not only is it obviously important in regards to sham contracting and other elements of disclosing loophole changes to be compliant with this contractor change, but you also don't want to be hit later along in a process with a large underpayment claim, or a large personal or annual leave claim being applicable because you hadn't reviewed these processes and your contractors succinctly. So obviously another key one is making sure that you have a good knowledge of these definitions and all the changes, and how they can affect your business specifically as well. So just doing a really good deep dive into your casuals and your contractors, their rosters, the way your relationship is managed, is obviously really key from here on out. So that's pretty much me. Hopefully it's all been really helpful, and keen to jump into those questions soon, but I will just jump over to Greg for now.
Thank you very much, Olivia. So if you've got any questions, please do drop them into the Q&A function at the bottom of the screen there. But just to kick off, there's kind of, I think, for some people, a bit of a so what, particularly around the definition of casual employment. So if I've got that definition wrong, if I've got someone who really should be a permanent employee, but I'm paying them as a casual, they're happy with that. Does it really matter? And am I going to get into trouble for that? Or is it only when someone gets unhappy about a situation?
Yeah, as I mentioned, the employees can decide or opt to stay and remain a casual. I think the key thing there is making sure that there's a document of that, but also the pressure that may be around that too. So making sure that it's very very implied within records, or very understood within records, that it was the employee's choice and not the employer's pressure on an employee to have that casual, to not have that casual conversion. Sorry. But look, it is quite important, especially considering you may have a casual who, right now at this date is more than happy being a casual, but in 6 months' time, something may happen in the business and all of a sudden they're not happy being a casual. That could flow on for the prospect of those underpayment claims too. So, really key to make sure that there's record keeping, but also if somebody, is looking at potentially that rejection of casual conversion, that there's notes to say that that was their choice.
Thank you. How does the definition of employment under the revised Fair Work Act affect the classification of workers across different industries? Are there different impacts on different industries?
Yeah, definitely. There's a lot of industries. I would say personally, I think that the fitness industry really struggled with the contractor change. In comparison, I do know a lot of support worker areas again struggled with those casual workers as well. Obviously, retail again too, lots of casuals. There's always different industries that can be affected in different ways. But specifically, I would say that the discussions that we've had, the tips we've had, could run within any industry, and should be applicable. But I think just there will be more industries who potentially get hit a little bit harder.
Okay. Question about federal government contracting and the interface with that. How do the changes impact independent contractors who typically contract to the Commonwealth via an intermediary for multi-year contracts. They have little control, must use their tools and maintain a regular pattern of work. It seems like they'll be hard to be defined as anything other than an employee. Would that be fair?
Yeah, it could be. But look, again, it may be a factor that they potentially need to alter the way that their relationship is managed. If it is that there's potentially a government funded way in which they're having those projects or something like that, again, kind of looking at that multi-factor test, because it may mean that you meet a lot of both of the criterias, and you just need to define better in one of those sort of factors within the table, one or the other, essentially. So I think just potentially looking at the situation, looking at the multi-factor test, and making sure that you're defining early on prior to the relationship is really key. But yeah, you're exactly right. Sometimes there might not be an option, but it's sort of all part and parcel with this closing loophole, unfortunately.
So just on that multi-factor test, if my contractor only fits some of the key components of that test for determining their status as an employee, how can businesses apply it effectively if you kind of left a bit of bulk there?
Yeah, so as I kind of mentioned, you might alter some of the relationship to kind of fit into one or the other. Another option is I do kind of like to almost have that table out. As mentioned, the ATO does that have that table pretty well stipulated as well. And you can almost tick each box as you go along as to whether they're in that employee or whether they're in that contractor box. If you're sitting at, a majority within the employee box, really making sure that you're looking at that relationship, because it's probably more likely that it's going to be that employee section. And when you're looking at the law in particular as well, they always take that factor within, especially employment law, of beyond a reasonable doubt. So, is there beyond that reasonable doubt that, yes, they're an employee or yes, they're a contractor? So it might not meet 100% of that contractor section, but as long as the majority or beyond that reasonable doubt is contractor, then you're feeling pretty safe.
Okay. If I'm currently employing someone as a casual, and I've done that for years and years, does the waiting period of 6 or 12 months still apply?
Yeah, generally speaking, I would take that into factor. But look, if you've had someone who's been there for over 6 months, again, I would kind of download an Excel, take your start date of all your staff, if that's something you're looking at the moment, and pretty much anyone above 6 months, I'd really be looking into your casuals. So it wouldn't kind of restart, but essentially when you're looking at that roster period, you do take a 6-month period from the date that you're reviewing.
Right, thank you. Now, if there's any further questions for Olivia, there's just one still outstanding. So if there's any further questions, please drop them into that Q&A box. But the other question is, how can I proactively adjust my policies and contracts to comply with the Fair Work regulations?
Yeah, so I guess with policies, and they're sort of generally pretty fair. But in terms of contracts, I think just making sure that you're having that review of those fair contract terms. Again, it may mean that you get extra representation to help with that process. But generally speaking, your code of conduct, employee handbook, all those kind of elements are really crucial for a business. And most of those can generally stay the same with these changes.
Thank you. Now, a further question is that if I'm converting a casual to a permanent employee, does the hourly rate need to carry over? So should the permanent rate be equal to their casual hourly rate, which would have included a casual loading?
If you would like to, yes, of course. But generally speaking, you only need to meet the modern award standard if you're a part of a modern award. So as an example, if the modern award for under the Health Professionals and Support Services Award, as an example, is $26 for a level 3 as a base rate for a permanent, that will have a 25% increase for a casual loading. You don't need to apply that 25% increase because they'll be receiving the benefit of annual leave and personal leave. So again, that's why it's quite crucial in that consultation, if you are changing an employee over from casual to permanent, to let them know that that will mean a change to their salary. And again, that may be why potentially an employee is rejecting the offer to move to permanency and may wish to remain a casual potentially.
Okay. All right. I don't think we've got any further questions coming through in the chat. So look, we might draw this to a close then. Olivia Perry, thank you very much for your time today. Really great insights and information, I think, for our members and others who might be on the call. We will have a fact sheet and a short survey that we will distribute to people shortly after the webinar. So we'll make a recording of this available as well. So if you do have any further questions, please do reach out to the Canberra Business Chamber Employer Assist team on 1300 277 881 or just get in touch via our website. So with that, I'll thank you, Olivia, and there's a couple of thanks coming through in the Q&A as well. So thank you very much, and look forward to seeing you again.